I am Assistant Professor Kritika Dev from LJ School of Law. Today we'll be dealing with the Indian Evidence Act and a topic in which you might get bit confused, but which is not a very tough topic. But when it comes to the Evidence Act itself, it has given two perspectives of that very term. Right now, what the term is and what are those two conflicting statements which are given under Indian Evidence Act, let's have a look. Now, the term about which I was talking is accomplice. Now, who is an accomplice? What do we understand by an accomplice? Is accomplice a synonym of the co-accused? Or is it some other term or some other companion? So let me clear your doubt. When it comes to the accomplice is a person who helps the main accused in any of the ways, right? It might help the person in doing a small act, or maybe before the act, after the act, or during the act. But when it comes to the co-accused is equally involved in the offense. So when it comes to the accomplice is a person who helps the main accused in order to completion of the offense, or maybe as we can see with the next slide, the categories of the accomplice. So here, as we see the categories are principal offender of the first or second degree, accessories before the fact. Now, if at all, the accomplice helps the main accused before the occurrence of the offense, then also the person will be treated as an accomplice. Or accessories after the fact. If the co-accused, apologize for the same, if the accomplice helps after the very fact or after the commission of the offense, then also the person will be treated as an accomplice. So these are the categories of the accomplice. So by this we can derive that accomplice is a person who actually helps the main accused. Right now, how do they help and what is there, that will get to see under section 133. Now, an accomplice shall be a competent witness. So we have got the term. What do we understand by accomplice? So he could be a person who is just helping. Just helping means it could be before the offense also, it could be after the offense also, it could be during the offense also. Now, an accomplice shall be a competent witness against an accused person. So, if at all here, in the case, accomplice comes as in witness, right? And, for say, A has committed a crime, maybe theft or maybe any other crime. So he had actually, in order to be of a helpful nature and to be considered as an accomplice, he gave a big bag where the theft property can be taken in that bag. Let's assume that. So here A has helped uh, A has helped B. If I've taken A and B correctly, so here A is the accomplice. A for accomplice, right? So A is the person who is helping B by giving a big bag before the theft. So A was accomplying B. He was the accomplice in that very offense because he helped, though before the crime, but he had helped B to do so. Right? In order to, he has provided a bag where he could keep everything which was the subject matter of theft. So under this section it is said that such accomplice, in this case it is A, will be treated as a competent witness against the accused. So if at all here A comes as a witness against B, then not only he'll be taken as a competent witness, but the conviction will not be illegal merely because it proceeds upon the uncorroborated testimony of the accomplice. By this you can derive that it will be actually legal if it is being said negatively. Let's take this sentence positively, that if the conviction relies upon the uncorroborated evidence, it means A has come as a competent witness against B. A was the accomplice in the same offense, but he came up as a witness. Now, if at all he has not been corroborated with the help of other evidences, there are not other evidence in order to corroborate uh, his competency, and the whole proceeding is upon that, or the whole conviction, the B gets convicted of theft merely on the statement given by statement given by A here. So it will not be illegal. It will not be illegal means it will be legal, even if it is there was no other evidence to corroborate the same. So here accomplice is a competent witness. So here A gives that very evidence that no, B has committed that very offense, B has committed theft. Though I have passed on the bag to him, but I know he had committed the offense and he had come as a competent witness. And the whole conviction can rely upon his very statement, the statement of an accomplice. Yes. Now, as I was saying, there is some dispute between two sections. Now, what are those two sections? So, here, under section 114 uh, uh, of the Indian Evidence Act itself, there is illustration B, which is given under this very section. Now, what illustration has been given under the illustration? Now, let me tell it to you very clearly. When it comes to illustration under Indian Evidence Act, illustrations are actually been given to make you understand the section in a more better way. They're not just simple examples which are being given. If you would like to take it, you take it, otherwise you don't take it. They are in order to explain a section in a more elaborative manner. So, in the illustration, it is given that an accomplice is unworthy of credit unless he is corroborated in material particulars. Right? So, here by the illustration, you can say that it is simply written that he is unworthy of credit unless he is corroborated in material particulars. So both the statements are corroborated. The first one in section 133, as we had seen, that he shall be a competent witness. And here it is written, an accomplice is unworthy of credit, conflicting. Secondly, unless he is corroborated in material particulars. So corroboration is necessary if we look into the illustration. But when it comes to section 133, whole conviction can rely upon the statement given by the accomplice, and even if it is not been corroborated, that will be valid. If it will not be illegal means it is legal. The whole conviction can rely uh, upon the accomplice witness, even if it is not corroborated. So of course these two are of a conflicting nature in each and every word that they are stating, but when it comes to an illustration and when it comes to an main section, of course the section will prevail, because illustration is there in order to make the meaning bit clear, but illustration is not the section in itself. But when it comes to a section, it is a whole section where the complete thing can be relied upon. So here section 133 will prevail over the illustration B of section 114. Right? But here, when it comes to actually the accomplice statement, court generally takes proper care. And when it comes to the real world, courts they do take care when it comes to the uh, accomplice witness. He might be an interested witness. He might be doing it in order to avoid his own punishment or own consequences. Right? So there are a number of things which are attached to it. So at the end, let's see one case law, that is Dalpat Singh versus State of Rajasthan. Now what happened under this very case? So here there were these two people, Dalpat Singh of course and Balwant Singh. Now Dalpat Singh and Balwant Singh, they were the two people who were posted at the borders. So at that post, the border post, they used to actually threaten the villagers that if they do not pay certain amount to them, they will arrest them on the charge of smuggling and all. So now during that situation only, there was one more person called Muhammad. They asked the same amount to from Muhammad as, and the amount was 200. Muhammad was not willing to pay that very amount, and he narrated everything to the CID officer. Now, when the CID officer got to know about it, they took him as a as a trap witness. So they asked him that you kindly give those notes, but do count the numbers and tell us to us in advance. So he counted the numbers on the note, the unique note numbers, and then he handed over the same to Dalpat Singh. So later on, the DSP when came, and of course he was there involved in it. Involved as in he was there to trap Dalpat Singh. So when he asked Dalpat Singh to show that the bunch of notes, initially he hesitated, but later on he had to show it to the senior, of course. And he was caught red-handed because the numbers were the same. So here Dalpat Singh the accused took the plea that when it comes to Muhammad and the DSP, they were the accomplice of each other. Therefore, the court cannot rely upon their statements. But in this, the court stated that Muhammad and DSP, Muhammad behaved in such a manner. He was not a habitual briber. He never used to give. It was not in his nature to bribe. He did so in order to trap Dalpat Singh. He did not do it intentionally. He never used to do it intentionally. He never did that before. So it was for the first time, and that too he did so unwillingly to trap Dalpat Singh. And of course, this fact was known to the DYSP as well. So they will not be termed as the accomplice of each other, and Dalpat Singh was prosecuted. So this very plea was not being taken from in this very case from the accused, of course. So here we are done with the concept of accomplice, and we have also seen a case law which talks about the accomplice, that in every cases it is not possible to state somebody as the accomplice and the court will rely upon you, right? We have also seen the difference between the illustration B of section 114 and the main section, that is 133 of the Indian Evidence Act. So with this, I would like to take your leave, and as I always say, keep reading, keep studying, keep revising so that you can connect to the sessions in future. Thank you so much.